make sure that the Facebook application was working. So we'll just wait. We're talking this morning about, excuse me, about bail reform and the reform of the bail reform because it wasn't working. So we're going to go into that today on the radio show in just a couple of minutes. I just wanted to make sure that the Facebook Live was working because I haven't been able to get it to work on my computer lately. So now it's working, and that's good. So it is now 8:58. In 2 minutes, we'll be going on the radio. I've been doing the radio show remotely from home with cats and grandchildren and everybody else around because we are still in the middle of a COVID-19 thing, and the radio show doesn't want people in the studio that don't absolutely need to be there. So I can do my show by call-in, and I have been doing my show by call-in. So we're going to continue that for the duration of the future. I've got my cat sitting next to me. I'm petting one of my cats. This is actually my cat. This is one of my cats. He's not happy about being picked up. He's a big cat. He loves to be pet, but he doesn't like to be picked up. His name is Fresno. And so we're going to be doing it this way for a while, apparently. I'm not in the studio. I like going to the studio. It's a more professional environment, and it's quiet, and, I know that nobody's going to come running by, but this is the new normal for us. And so in the studio, I'd have to be wearing a mask. You might not be able to hear me. Kelly Anderson's wife. I'm getting a phone call, which I am going to have to take. So I'm going to end the video and then come back in a minute. Can't do that. Okay. Good morning, Frank. Let me know when it's time. Yep.
I'll try to play the music again in the background.
Okay, sounds good.
The rejoin just started.
Okay.
Okay, go ahead.
Good morning, everyone, and welcome to Law Talk. Today we're going to talk about the new bail reform laws that just were revised. You may recall that in January of 2020, Section 240 of the Criminal Procedure Law was replaced by the new Section 245. And this section had forbidden judges to put any bail on misdemeanors, and among a lot of other things, but we'll talk about that in a minute. So it didn't have any exceptions for people who repeatedly committed misdemeanors. It didn't have exceptions for, what if you kept having the same victim, committing the same kind of crime. As long as it was a misdemeanor, they had to turn you back on the street. Didn't matter if they had video of you doing the crime. Didn't matter if you admitted doing the crime. You were set back out on the street. And the idea behind this was a good idea. A lot of people wound up spending a long time in jail because they couldn't afford the bail that was set. And while in New York State, the judges are not allowed to consider danger to the community, which is kind of interesting because in almost every other state, including Pennsylvania, just to the south of us, the judge can consider whether or not this person is a danger to the community. But in New York State, that was never a consideration because truly you're innocent until and unless proven guilty. So you couldn't be considered a danger to the community because we didn't know whether or not you did whatever you were accused of yet. So the criteria is really just, are you a flight risk? Are you going to come back to court, or are you not going to come back to court? And that was the purpose of bail. But in fact, they often did consider, practically speaking, not on the record, but they often did consider, well, is this person a danger to the community when they were setting bail, or theoretically a danger to the community? And so they would set bail sometimes really too high. I mean, you might say, all right, $500 isn't much money to some people, but to some people, that's everything. If you're only making $400 or $500 a week, and you have, rent and utilities and food and all this other stuff to pay, you don't have an extra $500 lying around. So people would wind up in jail, and they couldn't make bail, and they couldn't they couldn't keep their jobs. A lot of times they couldn't keep their housing. If they were making payments on cars, they couldn't make their car payments, child support payments, all kinds of payments that they couldn't make because they were in jail and they lost their job and they hadn't even been convicted of anything. And so this was and is a real injustice. And so the bail reform laws were made. Unfortunately, when you completely take away judges' discretion, we had a case here in the Southern Tier where a man had committed 20 or so misdemeanors since the law went into effect, and they couldn't hold him, and they were all like criminal mischief types. Well, as far as I know, I mean, I didn't follow the case that closely, but what I read about in the paper were criminal mischief type things. You know, slashing tires and doing property damage, and that's what repeatedly and on camera. But the judge couldn't hold him, couldn't set bail because it was a misdemeanor. So now a lot of those things have been revised. And it was revised 3 months in. And it's interesting because we hadn't made any revisions to bail laws or criminal justice reform since the 1970s. So, 40, 50 years go by and we haven't done anything with criminal justice reform. And then they do this incredibly drastic reform. And so they amended it in early April. So, a little more than 3 months into seeing how this law works, they realized it didn't. And the most important, I guess, change to the law is that there are now more situations where the judges can set cash bail even for misdemeanors. The updates went into effect just on July 1st, 2020. So this is the first radio show I've been able to do since they've gone into effect. So the changes are now in effect. And our state's prison population, to give some background on this, decreased by 30% between 2000 and 2016. So we were letting a lot of people out of prison, not as many people, there were not as many crimes being committed. The crime rate has actually been dropping for a long time, except for the last, few months. But some 45,000 New Yorkers remains in prison. And that was a lot due to the fact that people were pre-trial. They weren't even in prison or jail because they had done something wrong, provably, but just because they were suspected of doing something wrong because there was probable cause for an arrest. And then they were arrested and bail was set and they couldn't make bail. So you had all these people, really wasting their time in jail who hadn't even been convicted of a crime, which I think most of us agree is wrong. And then the other part of the problem is the parole system, and the parole system is going to be reformed next. So, buckle up your seatbelts because that's coming too. So, what happens with parole is that the parole officers are allowed and sometimes even required to take people who are on parole who may be otherwise doing really well, having a job, supporting their families, not getting involved in any more crimes. But if they don't make curfew, if they spend the night at their girlfriend or boyfriend's house, and they didn't get home by 10 o'clock or whatever when the curfew was supposed to be, according to their parole officer, they could be violated and sent back to jail just for that. Now, in practice, in my experience, they would wait until they accumulated a few violations before violating them, but they were often minor violations, and so someone would be thrown back in jail who might otherwise be doing well. And of course, this isn't everyone. I mean, some people, parole isn't for them, and they just aren't going to do well on parole and they don't follow the rules. Some people get rearrested. So I'm not saying everyone who's violated on parole is violated on parole on a technicality. But what I am saying is that when people are violated on a technicality, you have someone who's being a productive member of society, and then they're suddenly taken out of society because they didn't get home by 10 o'clock a couple of times, or they were late for or missed one of their appointments. And sometimes I have seen both in the parole situation and in the child abuse and neglect situation where a parent is going through parenting classes and getting counseling and such so that they can get their children back and raise them appropriately. Sometimes these appointments are canceled by the provider or by the organization, or like what happens on Juneteenth, all of a sudden the government decides we're shutting everything down. Now that's not very common, but sometimes a snow day or something. And that would be counted against someone as a missing of their appointment. And so you would have to go back, and it would be the burden would be on the parolee or the probationer to prove that they were innocent, because once you've been convicted of a crime and you're on parole or probation, they don't have to assume you're innocent of the violation anymore. That's a different standard there. So sometimes people would be sent back to jail or prison. So that reform is coming next. So what happens is that in our state's prison population, which is going down and has been going down, is now just in the last few months, there's been a lot more. There's been a spike in crime. And I guess it's been fairly obvious. There was one case where a woman attacked Jewish people 3 times in New York City, and she didn't attack them so bad that it was a felony, but it was definitely a hate crime. She was definitely attacking, just random people because they were Jewish, and they couldn't set bail. I mean, she was just let free to go do it again, and do it again she did. So there were several cases like this, which made it really clear that they had to reform this law because it wasn't working for everyone. They're just, you just have to accept that there are people who are going to violate the law if they can get away with it. There's also been an argument that some of the peaceful protests that have been hijacked by people who don't want to be so peaceful and, things get out of hand. Again, people could go and do what they wanted to do, and then they would be let out to go do it again because the law could not hold them if they kept their activities to a misdemeanor level. So you would go, you would get booked, and you'd be let out on the street again. So this wasn't working at all for anyone. So they decided, I would say for anyone, it wasn't working at all for the people who are trying to prosecute crimes for repeat offenders. For people who were getting misdemeanors, maybe it was the only time they ever got a misdemeanor and their lives weren't ruined. It definitely works for them. So they decided to reform the bail laws. Now, one of the things that I want to talk about too in the discovery laws is the role of the New York State Bar Association in making laws. For many years, I was a member of the New York State Bar Association Criminal Justice Executive Committee. And we're going to have to talk about that in a minute because it's time for a break.
All right, so you can hear that okay?
I heard it just fine, thanks. Wow, time goes by so quickly.
I know.
I got this mug from Puerto Rico. It's got lizards on it. I like it a lot. How much time will I have in the next segment, Frank?
It'll be another almost 10 minutes. That's a 9-minute segment after the break, and then you'll have another 10, give or take.
Okay, thank you.
Because I'm looking right now, it'll actually be about 9 minutes exactly.
Okay.
We're just about, the weather just started, so we got about 20 seconds here.
Okay.
So the rejoin just started. I'll tell you when it's over. Okay, go ahead.
So I was talking about the role of the New York State Bar Association in making laws. For years, I was on the New York State Bar Association's Criminal Justice Executive Committee, and then my life got busier, so I wasn't able to do that anymore. But what the New York State Bar Association has done for 144 years is be a really powerful. They don't call themselves a lobbying group. They call themselves a resource for legislators, and they are supposed to be neutral. And I'm sure they try. But I have to tell you that most of the people on the committees for the New York State Bar Association are, in my experience, the ones that I met. So speaking for people I met, were extremely liberal. And that was their viewpoint. And they didn't see themselves as being liberal. They saw themselves and their opinions as being mainstream. But they actually have an office at the Capitol. And so legislators from either side can come and ask the Bar Association, hey, what's the law on this? What does the research say? And so they have a lot of influence. And so one of the things that I have explained to people over the years is, it's important to have a seat at the table, but it's also important to have a seat at the right table. So if you're trying to get the laws changed in New York, you need to contact the appropriate New York State Bar Association Executive Committee, because a lot of times what they do is they'll write up laws and then they'll make them available for legislators to present. So the legislator in question will truthfully say, this is a law I presented, this is my law, but really it was written in many cases by the New York State Bar Association committees. And that's considered to be a good thing because you've had a group of lawyers look it over and see whether or not there's any problems with it that are anticipated. So if anybody wants to do anything to change laws, whether they be bail reform laws or parole reform laws, you're really going to have to talk to the New York State Bar Association to get super far in most cases. So now the reforms that took place July 1st made more people available for cash bail. So before, where the judge's hands were tied and they couldn't make cash bail for people, and they were going out, some of them, some small minority of people, but very public and very in the news people, were going out and just committing crime after crime because they couldn't be held, and they weren't thinking about the future when they would have a trial and how all of these different incidents they could be sentenced consecutively for. So for example, that woman who was let out after attacking Jewish people 3 times for misdemeanors, well, each misdemeanor is up to a year in jail. They were different days, different times, different events, so they don't necessarily run concurrently, and they shouldn't because of the way that she did that. So she was facing up to 3 consecutive years in jail, but apparently wasn't thinking about that. The young man who committed 20 crimes here in upstate New York, depending on the level of misdemeanor, he would be facing from 3 months to a year in jail for each one of those. So he could be spending a very long time in jail consecutively, but again, not really thinking about that. So sometimes the reason for putting people in jail and with cash bail is so they don't get themselves in trouble again, although that's not a legal criteria. I have heard judges say, well, if I let this person out, they're just going to go do something again and get themselves in more trouble. They're really safer in jail. And sometimes that's true. Sometimes if, a judge gets to know people, especially in small counties, small areas where you're a defendant, you might need to give them a cooling off period. That's not a legal criteria, but it is something that happens when cash bail is set. Now, that's not, again, the reason why cash bail is supposed to be set, but sometimes it happens. So there are more conditions now than there were in January that trigger cash bail eligibility. So judges will be able to set cash bail based not only on the crime committed or allegedly committed, but also on the person's legal history and status. So before July 1st, and from January to July 1st, they weren't allowed to consider your criminal record. So that's why the guy who did up to 20 or more things, just because he had been arrested 20 or more times and he wasn't convicted yet. Why wasn't he convicted yet? Because COVID-19, the courts aren't open. The local small courts that handle misdemeanors aren't open. So literally, they couldn't set bail on you and they couldn't prosecute you. So you can understand some people took advantage of the situation because that's the way their hearts are. They knew they could basically get away with it for quite some time. And so they did. So we literally had no functioning judiciary except to let people go for misdemeanors. And then the prosecutors couldn't prosecute because of COVID-19 because the smaller courts where they would prosecute were not open. And we're still not having trials in person. So anybody who's committed a crime between January and now, they're not being set for trial. And it'll be interesting to see whether or not the speedy trial rules that normally are in effect are considered to still be in effect. And so a lot of people are going to walk because they didn't get a speedy trial, or whether they're going to decide that there's some sort of extraordinary circumstances, although the Constitution doesn't provide that. The Constitution doesn't say you get a speedy trial unless there's extraordinary circumstances. The Constitution just says you're entitled to a speedy trial. So unless the Constitution is changed, a lot of attorneys, including myself, are thinking and wondering that maybe a lot of the people have been arrested. There's really no point in arresting them because it's going to have to be dropped because they did not get their speedy trial. Also, if someone is out on pretrial release now from an offense and they have a specific victim and then they go and they bother that victim again, they are going to be eligible for cash bail, even if it's a misdemeanor. And likewise, if you are, going around the community and terrorizing people or committing the same kind of vandalism, they're going to be able to set cash bail for you. So the idea is that people aren't going to be able to anymore commit crimes with impunity. They will be able to be held in jail. And this is kind of really worse now because the small courts that would be able to have a trial and determine whether or not you're guilty, again, are not functioning right now. So you're going to be in jail without the ability to have a trial and a final disposition of the situation that you've been accused of. So that's a real problem on the other side. So there are what they're trying to do now is to expand pretrial release conditions. So in other words, instead of just turning someone loose on the street, they're using electronic home monitoring. They're using you have to call in, every week or in some cases every day to an organization and let them know that you are still here, what you're doing, that you haven't been in any more trouble. So there are other conditions that might be put into place. So, for example, say a person was arrested for a drug or alcohol related crime. It's clear that they were drunk or high at the time they allegedly did whatever it is they allegedly did. The judge can order them into treatment as a condition of release. So you can be ordered. Now, there's some controversy about that too, because when people are ordered into treatment, that doesn't always work. The first step towards overcoming an addiction is to admitting you have an addiction. And some people, if the judge orders you to go and you didn't decide to go yourself and admit you have an addiction, it may not work. But it's something that the judges can do. And what I tell my clients, for example, if they're arrested for a DWI and they try to tell me, well, I don't have a drinking problem, I say, well, you were arrested for drunk driving. So that's a problem, and drinking was involved, so you have a drinking problem, whether you want to think you do or not. And so putting it that way, people can often accept what it is that they need to do. So, I mean, it's a good thing that the judges can order this, but I'm just saying it's not always going to work just because the judge tells you to go. So that can be a situation. And it looks like we're running out of time again. Okay, we'll see you after the break.
We'll be right back with Law Talk here on the Patriot.
That was a really quick 10 minutes.
Yeah, that one felt real quick. I looked up and I thought it was late. I was like, wow.
Yeah.
So this, when you come back, here, you'll have about 8 minutes.
Okay.
This was the longer break of the two.
Okay.
About 45 seconds here.
Okay.
All right, your rejoin's just about to start here. Okay, go ahead.
And welcome back to Law Talk. And we're talking about bail reform and revision of the bail reform law in the state of New York. And what happened is that now judges have the opportunity to set cash bail in more circumstances. However, they don't have to. Nothing requires a judge to set cash bail. So that's still in the law that the judge doesn't have to do that, but they now can do that in many more circumstances because the law just wasn't working. People who um, were taking advantage of it, I guess, ruined it for everybody, as often happens. The other part of criminal justice reform was that passed in January was that the district attorneys had to have discovery, what we call discovery, or the evidence that they have against the person. They used to be able to wait until just before trial, which wasn't really fair because people couldn't consider the evidence against them when they were considering a plea bargain. And often I had it said to me as a defense attorney, well, if you're going to demand discovery, then we're taking the offer off the table. So you wouldn't even get to see what it is that they had against your client. And, you know, you might have a client who's swearing they didn't do anything, but they're facing a lot of time. And you didn't even know what the chances were for them to have a good outcome at trial. So now the prosecutors have to get, with a revision in the law, they have to get you certain documents within 15 days or 30 days or 60 days before trial. Whereas under the old reformed law, if it was a misdemeanor, they had to get you all the evidence they were going to use within 15 days. And a lot of times the investigations weren't over when the person was arrested. They would arrest when they had probable cause to believe they committed a crime, when they believed that a crime had been committed according to the legal standards. But that doesn't mean the investigation was over. So a lot of times they couldn't get it within 15 days on a misdemeanor. So some district attorneys, I heard, just decided not to prosecute misdemeanors anymore because they were going to let them out anyway. And they had to have all this evidence into the defense attorney within 15 days, which a lot of times they couldn't do. So they just said, "The heck with it. We're not going to prosecute misdemeanors." And so that may also explain the spike in crime that has happened since the beginning of the year. So now they have more time to get everything to you as a defense attorney, or to your defense attorney, but they have to pursue what's called an open file policy. So in other words, as they get the evidence, they're supposed to be turning it over to the defendant and the defendant's attorney so that they can evaluate the evidence as they go along so that they have time to prepare for a trial. And some district attorneys did that anyway. For example, Joe Fazzari in Schuyler County has always been very good about giving open discovery. And that works out really well. The only time I ever had trials in Schuyler County were in murder cases where plea bargains are generally not offered. But in all of the other cases, I would say, I don't think I've had a trial in Schuyler County because they pursue an open file policy. And when two attorneys, a prosecutor and a defense attorney who know what they're doing, look at the evidence, you pretty much know where it's going to come out. So you talk about it, you discuss a plea bargain, and then you go make a plea if the person is guilty. And if the person is not guilty, then you talk about it, and sometimes they drop the charges. So it works out really well with open file policies, and I admire Mr. Fazzari for doing that. For the decades I've been doing this, he's been doing open file policy, and it works well, and it's fair to the defendants, and he gets convictions for people who should get convictions. So kudos to him. But now that's required across the state, that people have open file policies and that they don't play hide the ball, so to speak, with defense attorneys. And that's really good because I think most of the time my clients are telling me the truth. And I start out with the assumption that they're telling me the truth. But every now and then, there's been a couple of times, I'd say 2 or 3 times in my career, when I've been in the middle of a criminal defense trial and the people come up with something that they didn't show me before, and or a witness says something that I didn't know, something they weren't required to tell me, and it becomes clear even to me that my client has lied to me. And that's bad. And it's very clear when it happens with the jury and they get convicted. So this will enable me and other defense attorneys to say to the client in advance, look, here's the documents, or here's the video of what you did. So you told me X, but I can see now that this is Y, and the jury is going to see that it's Y. So you need to, man up or woman up and admit what you did and do a plea bargain because it's going to be worse for you after trial. So that saves the people money. That saves the people of the state of New York money because trials are expensive. You have to have jurors, you have to pay them, you have to pay the juror commissioner to do all kinds of work. It's a lot easier and faster and more streamlined. Often with a plea bargain, the person spends less time in jail, so you're not paying, for 3 meals a day and a bed and medical care for someone who's in the custody of the state if they make a plea bargain. So it's either they don't go to jail or they spend less time in jail, so it's cheaper. And people who have admitted what they've done usually do better on parole because they've done whatever they've done, or probation, depending on what there's a difference, but we won't get into that now. Um, but depending on what they've done, if they've gone ahead and they've admitted what they've done, and they need to go into treatment, or they need to take anger management classes, or whatever it is that they need to do, if they've made an admission, they're more likely to be successful in the outcome after the classes and everything. So if someone is guilty, the open file policy will help society get them the help that they need, and will help defense attorneys indicate to the client what the chances are of them doing or not doing well at trial. So this is much fairer to everybody. It's a lot cheaper for the taxpayers, and it makes a lot of sense. So I'm really happy with the new revision of the bail reform law, because society is kept safer than it was under the old 6-month-old bail revision law. But the defendant's rights are still protected. Cash bail is not required, and people are less likely to lose their jobs and their homes and their children because some sort of bail is required, and they can't afford to do it. So it really allows the flexibility that the judges should have. I mean, the judges are elected by the people who are going to be in the community that they're judging, and that's a good thing. So administrative law judges are different than criminal judges. Criminal judges in New York State are elected. So it's very important that they are elected, because then they get to, if people don't like the way they're doing it, they don't like the way they're sentencing, don't like the way they're making decisions, if in as much as they know about them, people can elect the judge out, just like you can vote out a district attorney or vote out a congressperson or anyone else. Judges in New York can be voted out. And with that, we're done with Law Talk for this week. So we'll see you next week. Have a good week, everybody.
The Law Talk here on the Patriot, your only home for political talk radio in the Twin Tiers, 1230 and 1450. That's on the AM dial, 106.9 and 103.3 on the FM dial. All right, sounds good. We'll talk to you next week.
Okay, thanks, Frank. Bye-bye.
Bye.
So thank you, everybody, for watching. It's been a good show, and we'll see you next week. Thanks, Rich. You all right? As usual.